5, 4, 3, 2, 1. However, the said circular dated 22/1/2019 clearly conveys the manner in which the EPFO treated the issue as regards the necessity of submitting options under para 26(6) of the scheme 1952, and it indicates that the submission of options was never made mandatory. In addition to the above, the petitioners have also raised a contention that in the judgment passed by the division bench of this court in Sasikumar P and others versus Union of India and others ILR 2019-1 Kerala 614, it was clarified that the employees shall be entitled to exercise the options stipulated by paragraph 26 of the EPF scheme without being restricted in doing so by the insistence on a date. Therefore, even if the submission of an option is mandatory, it is still open for the employees to submit the same without any cutoff date. It was further contended that even though the said judgment was set aside by the Honourable Supreme Court in Sasikumar's case supra, it would not affect the direction of the division bench judgment of this court in Sasikumar's case supra, as there is no contrary finding in the decision of the Honourable Supreme Court with regard to the option under para 26(6) of the scheme 1952. In my view, this is also a matter to be considered at the time of the final hearing. Thus, when all the above aspects are considered, it can be seen that right from the inception, higher contributions were being accepted by the EPFO even without submitting options under para 26(6) of the scheme 1952. It is also evident that in some cases instructions were issued from some of the offices of EPFO to accept the same, and in some cases accounts of respective employees were also updated in tune with such higher contributions. Further, the petitioners also have a contention that going by the language used in para 26(6) of the scheme 1952, it could be interpreted as an enabling provision which provides the power to the EPFO to accept higher contributions in certain circumstances, and the same cannot be treated as a provision which makes the submission of option mandatory. The exercise of such options and their acceptance by the EPFO can be inferred from the conduct of the employees, employers, and the EPFO as mentioned in circular dated 22/1/2019. After considering the provisions in this regard, I am of the view that this is also a relevant aspect to be considered in detail. Thus, when considering all the above aspects, the only view that can possibly be taken is that the petitioners have succeeded in establishing a prima facie case warranting an interim order in the matter. It is to be noted that the balance of convenience also favors the petitioners. Evidently, the Honourable Supreme Court fixed the cut-off date as 2/5/2022 for submitting the options. Now, on account of the insistence from the EPFO to furnish the details of the option under para 26(6) of the scheme 1952, and also in view of the peculiar nature of the online facility provided for such submissions, they are now prevented from submitting the said options. There cannot be any dispute that if they were not permitted to submit their options before the cutoff date, they would be deprived of their opportunity to claim the benefits of the judgment of the Honourable Supreme Court forever. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है।